accept the ruling of a court on an issue that does not seem to be the sort of thing courts usually decide. As a thoughtful commentator observed about another issue, the political process was moving not with Chief Justice Robert
Last occasion, I referred to two judgments of references. I'll make that complete and
Sure, sir.
in the course of the day, I'll be able to.
Certainly. So, Mr. Saswat Patra.
In the course of the day, I'll be able to.
Your Lordships, firstly, many thanks to you for giving me this 5 minutes post-lunch and posting it after. Deeply grateful, Your Lordships. Your Lordships, 3 points at which we stopped before lunch. First one, capacity and functionality of the Parliament. Second, role of the polity.
So what is the first point?
Capacity and functionality of the Parliament. Your Lordship, because I also am a practitioner from the Parliament, being a member, and also happen to be a vice chairman of the Rajya Sabha. So therefore, I'm trying to bring in very briefly in the 5 minutes that I have an evidence as to what goes behind capacity and functionality of the Parliament and why Parliament should hear this. Go after this. Second, role of the polity. Now, role of polity is very crucial, and I'll talk about that in a bit. And the third, impact on public policy due to legislative absence. Impact on public policy due to legislative absence. Lordship, I'll very briefly take by me. And that 3-page note, the first page, and I'll not go into any of the transcripts of that to save time. I'll come straight to para 3 and para 4 on page 2, which has a table. Or probably I'll also skip para 3. I'll just come to para 4 right away, Your Lordships. There is a table.
I don't think you have, no, your note.
We don't have it.
Joby Verghese.
Yes. Okay,
Oh, Joby Verghese.
Joby Verghese.
9-page note.
I have got hard copies as well, Your Lordship.
No, we've got it. We've got it.
Shakti Foundation.
Shakti Foundation. Yes, Your Lordship.
Yes.
Where you have mentioned this new bill, which is that Jan Vishwas.
Jan Vishwas Amendment of Provisions Bill 2022. Your Lordship, why have I mentioned it? It is already a public document which was presented to the Lok Sabha on 2023 and the Rajya Sabha. Today, we are talking about SMA as a canvas. But we all agree to an extent that without the personal laws being in the ambit, this entire matter cannot be taken up. I wanted to give an evidence in this effect through this Jan Vishwas bill, how the Parliament has the capacity and the functionality to deal in a matter which is having wider ramifications. This bill, Your Lordships, imagine this, 42 laws of this country are going to be in some way affected. 42 laws, 182 amendments across 19 ministries of this country. So for something as mammoth as this, it is the parliamentary committee, and in this case, it was a joint committee that was done, which actually has the capability, capacity, and functionality in order to go after and deal with a matter which deals with 182 amendments only in one bill, dealing with 19 ministries of this country, dealing with 42 laws of this country. That is my first part of the point that I'm trying to make, that if we are going forward in this matter, which will have wider ramifications, will have impact on other laws, then this could be a parameter to look at. Second, if you go to para 5, Your Lordship, I've spoken about the JPCs, the select committees. I'll not focus on that. The next one is para 6, surrogacy bill, sensitive, sent to a select committee, dealt with appropriately. The capacity and the functionality of the Parliament. Page 3, the mediation bill 2021, which is going to be tabled in the Parliament very soon. 23 meetings have gone through it, Your Lordship, to the department-related standing committee on personnel, public grievances, law and justice. To do what? To ensure that we have a foolproof law. To have this kind of a debate and discussion, the appropriate forum is the Parliament. I was a member of this committee, Your Lordship, when this mediation bill was being discussed. And the reason why I have tried to build on the first point, and I'll stop my first point here, is the capacity and the capability and the functionality of the parliament. I'll go to the second point, Your Lordship. I'll not take more than 5 minutes. I've committed to it. I won't. Second, role of polity. Your Lordship, we may talk about it as a social construct. We may talk about it as a legal construct. We may talk about it as a socio-legal construct. But unless you are able to flesh this out through the role of the polity, which has been absent so far, then it will not be very fruitful to be able to broad base it and take it right down to the bottom of the pyramid. In doing so, the role of the polity at this matter, we may have a declaration, Your Lordship, but the role of the polity in this matter has been completely silent. Where can we find that? We can find it through the parliament. Your Lordships, therefore, my point number 10, voice of 1.4 billion people. You have 788 members of parliament, 245 Rajya Sabha, 543 Lok Sabha, 12 of them appointed by the Honorable President of India. Wouldn't it be befitting to actually send something as widely impacting as this to the parliament to be dealt with appropriately and more holistically, where the canvas to deal with this which be much wider than the canvas that we're looking at? Third, and my final point, and I close, is the impact on public policy due to legislative absence. Your Lordships, let's assume for a moment we have a declaration. How do we execute that declaration? In Navtej, you have a declaration, fundamental right, taken up. In Vishakha, it went into a law, sexual harassment law. In terms of Shaira Bano, a law, a legislation. So whenever you find that there is a declaration, it goes into a law and thereby has public policy precepts that are added to it. In this case, because the parliament does not have or hasn't dealt with it, we may have a declaration, but the parliament may not go and dispose it of as a law. In that case, the declaration would be there. Writ of mandamus may be there, but the public policy precepts and the public policy implementation on the ground may be difficult. What would inter alia happen? You might have contempt notices coming. Therefore, Your Lordship, I'll close here, my 5 minutes are over, that these three basic parameters, capacity and functionality of the parliament, role of the polity, and impact on public policy due to legislative absence in this matter are extremely crucial. My humble and limited prayer, send it to the parliament. I'm not going into the merits of the matter at all. Whether it is right, whether it's wrong, I'm not going into it. I'm going on the very simple principle, send it to parliament, let the parliament deal with it. Thank you.
Thank you, Mr. Patra.
Deeply obliged.
This was Mr. Patra, the counsel, of course, arguing, not Mr. Patra as the parliamentarian.
Deeply grateful, Your Lord.
Thank you, Mr. Patra.
Thank you. Thank you, Lordship.
I've been goading him, Malas, to come more to court.
Yes.
He's slowly
Yes.
starting, Malas. I would.
Thank you. Thank you. Thank you, sir. Thank you.
We will also respectfully join in that chorus. Yes. We now hear Mr. Atulesh Kumar.
May I please note? My Lord, on my behalf, Mr. Nadkarni has already submitted, but I wish to make one point, my Lord. Although I am adopting the submission of Lord Solicitor General, Mr. Dwivedi and Tatar, my Lord, that in para 7 of my note, I've said, even that your Lordship told that you are not considering the personal law and considering only a special marriage act, my Lord, but But my Lord, a special marriage act is not in isolation. It affects the other personal rights and family law, my Lord. So for Hindu is concerned, my Lord. So in any divergence or deletion and addition in the special marriage act so far to include their submission, my Lord, it will certainly affect the us, my Lord, larger
It's
ramification.
been argued by others also.
Yes, my Lord.
Anything else that you would like to say which will not be?
I am adopting, my Lord, the same, my Lord. Obliged, my Lord,
Thank
deeply
you,
obliged.
Mr. Atulesh Kumar. Mr. Filza Muniz. Yes, Ms. Muniz.
On my behalf, my lords, my learned friend will argue, my lords.
Yes.
Please, please.
What do you mean on your behalf? Are you in person or?
No, no, my lords, I am.
He's the AOR, my lord.
Oh, you are the.
I'm Advocate Sanjeevani Agarwal, my lord, representing Light Life Freedom.
Sorry, what's the
NGO.
name?
Sanjeevani Agarwal.
Sanjeevani.
Obliged, my lord.
Yes, Sanjeevani.
My lord, I will be referring from the written submissions which were submitted yesterday. So it's like very brief.
Are they there? In whose name are they?
It is in Ms. Filza Muni's name, ma'am. My lord.
Do we have it?
I'll just check. 1 second. Sanjeev, Ravi
Okay.
Dekar.
Yes, sorry, I have.
Did you find it?
Yeah. 5 pages.
Yeah,
5
ma'am.
pages.
My lord, it is, I'll start from point number 2 and I'll be very brief. I understand most of the points have already been discussed. So under Article 21, right to marry is a universal right, my lord, but it is not a fundamental right. And I'll go back straight to point number 6. India is a developing nation having still fighting for the girl child basic rights, my lord.
You said
Point-
right to marry is a?
Is the right, my lord, it is not a fundamental right, though it is a universal right. It is humbly submitted that as per the economic survey of Ministry of Finance, 65% as per 2021 data, India's population lives in rural areas and they are ignorant people. They don't know about what same-sex marriage is and its repercussions. It is humbly submitted, therefore, my lord, that there are still questions and challenges which we have to resolve to lay the foundation of modern societies, especially in schools, where children are not aware of what same-sex marriage is and what sexual orientation is. During a parents-teachers meeting, my lord, how would a child react to a classmate having same-sex parents? We are still paving a way as a country to provide toilets to all citizens, and therefore we have
So social acceptability, you're saying? We got the
absolutely,
point,
my lord.
yes.
It's very, very important point.
All right, fair enough. What's the next point?
My lord, that's why it's important that we first create awareness on the subject before having a law which legalize same-sex marriage.
All
It is important that
That Sanjeevani has already been covered.
absolutely, my lord. I understand.
Thank you.
Highly
so much.
obliged, ma'am.
Thank you.
Highly obliged.
Mr. Gaurav Agarwal, thank you, Sanjeevani. Thank you, Filza. Gaurav kahan gaya? Mr. Agarwal doesn't seem to be all right. Then Mr. Som Thomas.
Yes, my lord. I am party in person. I've come from Bangalore just for this 2 minutes.
Yes.
My lords, I've made a detailed submission. There are about 7 points. I'll pick up only 3 quickly. First of all, marriage is a biological institution before it is a social institution. And Indian law is substantive in its coverage of marriage. Many jurisdictions that have legalized same-sex marriage are primarily procedural. Who can get married, how they can get married, in the presence of whom. But Indian law is substantive, and the specific point there is sexual intercourse, and sexual intercourse of a specific kind. And that is why there are words like consummation, there is the word impotence, there is the sense of fulfilling a responsibility, a sexual responsibility in marriage. And if that responsibility cannot be fulfilled or will not be fulfilled, the marriage fails. And the first cause for dissolution of a marriage that is listed in the laws is taking the sexual intercourse outside of marriage, what your lordship talked about exclusionary. But when the exclusion is violated, that becomes the first cause for breaking the marriage. So this specific type of sexual intercourse is the basis for making and breaking of marriage. This has to be recognized. And this is important as we go along. I have talked about in my submission about the burden on the state infrastructure for protecting families, basically family courts. For example, if two women friends live together in a flat, when does their relationship, their friendship become a marriage? What is the responsibility to each other in such a marriage? Two men living together, when they have disputes, can it be taken to a family court? What is the family court supposed to do with it? And if a bisexual is involved, does he or she have a right to go outside the marriage for multiple partners? Once family courts have to start dealing with all of this, they will necessarily have to start delinking this first element of marriage, sexual intercourse. They will have to kind of say, look, sexual intercourse is in the private domain and we don't want to get into it. Are there other ways we can look at it? So in that sense, the entire marriage narrative that has existed not just from 1950, but I would say 1950 BC and before that, predicated on sexual intercourse of a specific kind, will become less of sexual responsibility and more of sexual autonomy. This may work well for the petitioners, but this is not what marriage is. And my closing point on that is that there is then no cause for the government, for the state to give privilege to relationships per se that claim to be in varied colors, including bisexual multi-partner relationships. But we can give credence to the concept of a household. Even in Deepika Singh versus CAT, it was really the household and the protection of the children that was the concern and not relationships per se. And so even to the government, I have already written on the policy front that yes, you can have a concept of household. It doesn't have to depend on marriage or anything like that. There is a nexus between marriage and gender, which the other party denies. But there is no nexus between marriage and insurance, between marriage and gratuity necessarily. The guidelines can separate the two. In my corporate career, in the period between NAS and Kaushal, my company itself allowed employees to declare a partner for insurance, and it was done. So these are doable things without getting into the area of marriage, that to the substantive aspect of marriage. The other party is primarily keen on the procedural aspect of marriage. Give us marriage, give us the recognition, just give us a procedure to get through and get the label marriage. But what's the content of marriage we are concerned about as married people? I have 33 years of marriage behind me. I am concerned that marriage should and sex should remain in the arena of responsibility, not autonomy, because marriage is not autonomy. Marriage is where you give up autonomy and you work for a common good and you work for the children. That's what I wanted to say. Thank you, my lord.
Thank you, Mr. Thomas. Thank you for coming all the way from Mangalore to assist us. Deeply appreciated. Thank you. I think we are now concluding. Mr. Solicitor, would you like to?
Malathan 5.
Now, at some point now we'll have to close, apply closure now.
My name is on the list.
I've heard a diversity of viewpoints. Yes, all right. All right, 30 seconds for everyone, and then the solicitor.
I'll just take 2 minutes, Malad. My name is in
30 seconds. Yes, tell us. You are Gaurav Agarwal.
No, Malad.
All right.
Malad's recognition or declaration of bisexual or pansexual person's marriage will directly lead to bigamy and polygamy in this country, Malad.
All right.
I'll explain, Malad.
No, you made your point. Don't explain it.
No, Malad. Because if my lords will anyway...
We got your point. We got your point. That's all right. We understood the points. You don't have to. These are, we understand the line of thinking behind.
Only rights of bigamy or polygamy to bisexuals or pansexuals, my lords, will also have to grant it to heterosexuals and other LGBTQ people as well.
All right. All right. Thank you. What?
Malathan 501.13.
What's your name?
Council is appearing online, my lord.
What is your name?
Shashank. My name is Prashant Dikshit, my lords.
Prashant Dikshit.
Please.
Yes. So what's your name?
My lords, in 501.13, council is appearing online, my lords. He wishes to make submission for 30 seconds, my lords.
Who is appearing? Shashank Shekhar, Mr. Jha?
Yes, sir.
Yes, Mr. Jha.
I will just make 30 seconds point. Point number one, the petitioners,
Fastest finger first. Yes.
yeah, the petitioners claim that marriage is a private affair, and that is why they quoted Navtej, Puttuswamy, and etc. But the matter of the fact is that marriage is not private; it is social affair, sexual
All
interaction.
right, got the point. Thank you, Mr. Jha.
Point
Thank
number
you.
two. I will just take 30 seconds, not more than
Yes.
30. Point number two. Now, same-sex marriage is expected in heterosexual society or system currently before the court. But I guess the law, heterosexual law, which is in currently in hold, is not competent enough to give homosexuals those specific rights. And that is why you need to have new laws and not the changes in this
All
particular
right.
law.
Thank you. Now, who is next?
My IN number is 91562.
What's your name, sir?
My name is Group Captain Karan Singh Bhati.
Yes, Mr. Bhati.
And for Ex-Servicemen Lawyers Association, I am representing.
Yes, Mr. Bhati. What's the point?
Only one issue
Yes.
that Lordship is aware why it is necessary. In Joseph Saine, the first part, original judgment, did not deal with peculiar circumstances of armed forces. But the second, then the Constitutional Bench had to say, Lordship may bear that my application and submissions are only on that.
Thank you.
That it's an entirely different class, and it will create a havoc if such a thing is to come.
Thank you.
I am deeply
Who
aware.
else?
It's my IN number is
I'm Anson Thomas.
1 second, Mr. Thomas.
Milords 82649. Milords, I make only one point. The essence of family and the composition of family is unalterable.
All right. Thank you.
So therefore,
Next.
Milords, in a joint family, if a grandson marries, a same-sex marriage had happened, then the family composition is destroyed.
All right. Thank you very much. Who
Milords, I filed annexers also, Milords.
Yes, sure. Thank you. Who's next?
Your Lordship, Anson
1
Thomas.
second, Mr. Thomas.
My IA number is 9394.
What's the point you're making?
Yes.
And please introduce yourself.
Yeah. First point is that the issue is my name is Gaurav Kumar Agarwal. I am representing.
Yes, Mr. Agarwal. Yes.
Yeah. First point is that it is the issue regarding the nomenclature that petitioner want the use of the term marriage, whereas we are denying this. Because
All right. Thank you.
Second point,
Yes.
one more point. The purpose of marriage is to have legitimate children, my lord.
All right. Thank you. We've heard that before. Yes. Thank you. Yes.
My IA number is 67242.
आपका नाम पूछिए.
Dr. APC.
Yes.
On behalf of Anita Chauhan, he is the applicant, my lord.
What's the point? What's the
My
point?
lord, my point is same-sex marriage is totally unnatural, as per unnatural, and against the health parameter as per World Health Organization.
All right. Thank you.
First point, my lord. Second, Union of India has shown a specific section which apply only to biological men and women.
All
Third
right,
point, my
thank
lord.
you.
Legal recognition for same-sex marriage in unlawful, illegal, because the notion of marriage itself necessarily proposes union between two persons.
All
of
right. Thank you,
opposite
Mr.
sex.
Singh. Who else now? Anybody else left?
My name is Dhaval Unyal.
Yes, Mr. Unian.
Only one point, as we rely upon the written submissions, the fundamental right of an adopted child. Para number 10.
Ms. Bhati has argued that today in the morning. Thank you. Yes.
Just only 1 minute. Naveen Pahava. So justice of all. But it's only one submission that the doctrine of reading down can be achieved only, my lords, without making any bend in the law, without making extensive additions or deletions, etc., which is not possible in the facts of the present case.
Thank you. Thank you. Anybody else now?
We have
Mr. Solicitor?
submissions already.
Mr. Solicitor.
Well, I'll take just 5 minutes
Yes.
and not more, my lord.
Anson Thomas.
Mr. Solicitor, just 1 second. Mr. Thomas, what did you want to say? Just give us.
IA 83410, my letter to the Honorable Chief Justice on 13 March and also on 17th April that
Yes,
Chief
what's the
Justice
point
of
you're making, Mr.
India should
Thomas?
recuse. Chief Justice of India should recuse in this particular matter.
Thank you,
Would
Mr.
like to
Thomas.
kindly take it on record.
Yes, application rejected.
I
Yes,
would object
Mr.
to this, but leave it at that, my lord.
Yes.
Please ignore, my lord, some aberrations, my lord. I object, my lord. Since he has made the submission, I officially object to this submission being made. Not 5 minutes. Lord, during yesterday's dialogue, my lord, it fell that there is a possibility of a declaration being made, something less than marriage, but something more than the present status. Lord, having examined that, my lord, why, my lord, that may not be a correct course of action, my lord. Lord, your lordship's declaration would be a law within the meaning of Article 141, binding all, not just all courts, binding the whole nation. The difficulty would be this. Lord, any declaration of law would bind every individual in the country who is not before your lordships. In case of a law, every individual is represented by his chosen representative. That is the first issue. Your lordships are aware about the judgment in that baker's case, where, my lord, one baker refused to bake a cake in a same-sex marriage, and, my lord, he was prosecuted, etc. Similar thing happened, my lord, after the judgment of the American Supreme Court, my lord, 5 versus 4, one pastor refused to perform the ceremony of marriage. And he was sought to be prosecuted, and they have to come out with a law, what is called, my lord, the Pastor Protection Act. Now examine, my lord, a situation where your lordship declares the law. Your lordships would obviously not be declaring the contours of the declaration, the regulatory powers, what will be the regulation, who will be bound, who will not be bound. Suppose someone goes to a priest for performing a particular ritual, and priest says that as per my religion, it is only the husband and wife who can sit, a man and a woman who can sit in performance of that ritual. I will not be a party to it. I am posing a question to myself, would he not be guilty of contempt of your lordship's declaration? Lord, what would be the position, my lord, in case of, say, visa? My lord, where a wife gets the entitlement to visa, but only
See, that's a matter of that priest's fundamental right to follow his conscience and faith.
Lord, where that conscience stops and where his
That is
duty
where-
ends
that
or
is where-
begins.
So that's where solicitor, what is the kind, form, content, and contours of the declaration is important.
Correct.
We are all presuming
Yes, my lord.
that the declaration will be in the form of a writ that grant this or grant that. This is what we are accustomed to. What I was hinting was, as a constitutional court, we recognize only a state of affairs and draw the limit there and say.
I'm grateful, my lord. My worry was this. Whenever, my lord, a declaration is made either by legislature or by the court, legislature has the wherewithal to regulate the fallout. Your lordships would not be able to, first of all, foresee, envisage, comprehend, and thereafter deal with the fallout of that declaration. Fallout can be manifold in various facets of life. In
You're
various,
basically saying that any declaration of this court will really, in that sense, apply to every one individual in the nation and preempt the legislature from considering.
No, my lord, I am slightly on a different point. It may not even preempt the legislature. Legislature can still do something. But that would be, my lord, and for that, my lord, I would, my lord, one paragraph I am tempted to read from, my lord, this Obergefell judgment, my lord.
That's okay. We'll read
Only one para, my lord, for my satisfaction.
Tell us the para number, that's all.
No, my
Just
lord,
so
I would wish, my lord, your lordship, read
right.
it won't take more than 2 minutes. It 2463. 2463, volume 4 of the petitioner's compilation. For my satisfaction, please have a look. And this angle, my lord, is missed by all of us. And we also, my lord, feel that there would be some disservice, as Chief Justice Roberts points out, my lord, to the petitioners. And therefore, my lord, I wish to read it. My lord, kindly have a look at 2463. I'll just read, my lord. When decisions are reached through democratic means, some people will inevitably be disappointed with the result. But those whose views do not prevail at least know that they had their say and accordingly are, in the tradition of our political culture, reconciled to the result of a fair and honest debate. In addition, they can gear up to raise the issue later hoping to persuade enough on the winning side to think again. That is exactly how our system of governance is supposed to be. But today, the court puts a stop to all that. Look, this is what, in my submission, the declaration would mean. But today, the court puts a stop to all that. By deciding this question under the Constitution, the court removes it.
It's very important that you read that. What is put out there is,
Yes.
the Chief Justice is highlighting that the declaration that they have a right to marry. What was that? Justice Kennedy declared that gay couples have a right to marry.
Correct, my lords.
Now, we are intensely aware of that. We are intensely aware of that.
I'm grateful, my lord. Kindly, my lord, something further, which is on a slightly different point. Therefore, I would like to read it fully, my lord. There will be consequences to shutting down the political process on an issue of such profound public significance. Closing debate tends to close minds. People denied a voice are less likely to accept the ruling of a court on an issue that does not seem to be the sort of thing courts usually decide. As a thoughtful commentator observed about another issue, the political process was moving not swiftly enough for advocates of quick, complete change, but majoritarian institutions were listening to and acting. Kindly avoid, my lord, the citation part. This is crucial, and this is another dimension which Chief Justice Robert gives, my lord. Indeed, however, please note this. Indeed, however, heartened the proponents of same-sex marriage might be on this day, it is worth acknowledging what they have lost. From their point of view, the court says, indeed, however heartened the proponents of same-sex marriage might be on this day, it is worth acknowledging that they have lost and lost forever the opportunity to win the true acceptance that comes from persuading their fellow citizens of the justice of their cause. And they lose this just when the winds of change were freshening at their backs.
Thank you, Mr. Solicitor.
My lord, only last, my lord, it's my duty, my lord, therefore I am pointing out. My lord, at the outset, I said that we have written letters to the state governments. My lord, there are 7 responses. I'm not reading them. From Manipur, Andhra Pradesh, Uttar Pradesh, Maharashtra, Assam, Sikkim, and Rajasthan. I'm placing them on record. Rajasthan takes the position that we have examined it and we are opposed to the position, my lord, which the petitioners are taking. All rest say that this needs a very intense and expansive debate, and we would not be able to respond immediately. My lord, we have received this. I'll, my lord, file it on in the registry with copies to the other side, my lords. So, my lord, these are my closing submissions, but I'm just putting it on record, my lord. I'm not reading them. They are 1.5 page closing submissions, my lord. I'll place it on record.
Yes, Dr. Singhvi.
Lordships don't mind, my lord. I know it's a little unusual. Lord, my colleague has, amongst all, worked it, my lord, to the best. If he can be given, my lord, some time, my lord, few minutes, my lord, Mr. Agarwal.
After you have concluded. Thank you. Yes, Mr.
All right.
Singhvi.
May it please you, my lords. Now, my lords, your lordships has heard us very patiently. I've either been present or been made aware, my lords, so your lordship may take it. I know, my lords, the broad trends of the argument, and I'll answer them one by one. From mere cohabitation to a mere, I use the word mere, my lords, declaration of same-sex marriage, to a further declaration of same-sex marriage valid under SMA, which is what I'm asking. There's a difference between my 2 and 3 minutes. Same-sex marriage valid under and through SMA. From that, this whole balance excessive to the point of being balance actually wrong. Emphasis on legislative intent. Put in 5 different ways. Go to the legislature, original intent, rewriting, judicial legislation, judicial surgery. I'll be dealing with all, but I'm just saying, I'm cognizant of all that. Then to the, what we call the scare argument. Oh, my lords, how will it work? The workability argument. It's an attempt, to create, I'll be dealing specifically with the workability argument.
and then finally to the notice and objections. Now, my lords, I will be very pointed. It may not happen in the sequence my lords would want it, but I'll be covering all this. But my arguments are broadly under three heads. And your lordship members kindly consider following those three heads because they will come. Sometimes your lordship's query may relate to the third head. Lordship, rest assured, it will come there. The first head, with great respect, is that a constitution compliant reading.
We didn't respond to this, my lord. Your lordship said we'll not go into this. Notice and etc., my lord.
No, my lord did not give a judgment, my lord. Your lordship made an observation.
We're not going into it in these.
With respect.
Did say, therefore, we didn't.
As I recall, when the arguments were being addressed,
I argued it fully in the opening.
We said that this is common to, this is not specific to the same-sex
heterosexuals also.
And therefore, we said we'll not really deal with it in this batch. We have petitions which are pending.
That's what your lordship segregated.
And I have petitions.
That's what we didn't waste your lordship's time.
I argued it fully in the opening.
But Dr. Singhvi, keep it aside because we haven't heard them. Otherwise, we would have pointed out to them that they have missed out on.
That is, according to us.
Purposefully, we did that.
That is, if your lordship has to hear them briefly on that tomorrow. That is the heart, the heart of our objections.
No, 1 second, Dr. Singhvi, we have petitions which are pending specifically on this challenge. And the reason why we thought we'll not deal with it in this batch of matters is that that's a matter which is common to both heterosexual couples as well as to...
I was addressing that argument. Your lordships, just 1 minute, Mr. Mehta.
I'm sorry.
Your lordships observed, when I argued it fully in the opening, your lordship said that because it is common, I said, just 1 second. I said that merely because it is common to another segment.
If you don't mind.
I'm sorry.
Inherently unfair to the learned solicitor and all those who followed on this side that they went by our telling them that we are not going to.
Can I just clarify? I hear a lot of
together with the subject wise, and we consciously decided that
judge is saying what you are.
And in a sense, our suggestion really led them to a sense of
No. I am with it. Far be it from me to take away any natural justice from anywhere. That's not the point. Give me just 2 minutes. I raised it, argued it fully. In the course of arguments, your lordship observed, at which time only Mr. Ramchandran was there, Mr. Grover were there. They protested that this is the heart of our claim. The lordship said we'll take a call later. Now, if procedure is violated, your lordship certainly may hear them briefly tomorrow. But according to us, the heart, well, I'll take only a very short while on that. I've argued it fully in the opening. Your lordship's point was that if heterosexual couples to whom this regime equally applies are not present before us, should we not take it separately? That was a short point made, I have dealt with it fully in my written submissions. Your lordship's test is a positive test.
See, Dr. Singh, just answer this.
Yes.
We were not here when the reference was made. There is no reference order per se. The order was implicit on this premise that the claim for same-sex marriage was being considered. The court, to be fair to the court, nobody pointed out these nitty-gritties of the claims, the details of these claims, or even Section 7 SMA. Therefore, to stand up and say we have been heard, and please insisting that we must be heard and you must have a ruling is not up to you.
No,
because see, orders don't reflect. There is a consensus. The consensus was that let the same-sex marriage claim be heard.
Can I just say? Your lordship will recollect, I argued almost for half an hour on this issue in the open.
You did.
Then,
no
after
doubt,
that, ultimately the only issue is the lordship has not heard them. Your lordship may hear them briefly because, your lordship's test is, give me a minute. My lord, the Chief Justice's observation, I just want to take 2 minutes on that. Your lordship's test is that is an identifiable class genuinely aggrieved with locus before me. If a genuinely aggrieved identifiable class like me, which is directly agreed by that is before your lordships, then your lordship will not hear me on the basis that another class also is not before your lordships. The only issue, heterosexual couples, we are not concerned with, Balas. We are saying that the notice and objections regime, well, ultimately it boils down to
But look at it this way. One second.
Time.
There's another problem.
Yes.
Your argument in the challenge to the notice provisions postulates a verdict in your favor that there is a right to marry under the Special Marriage Act.
Of course.
All right. Now, therefore, the question as to whether, otherwise the notice provision doesn't apply to same-sex couples at all. Right? Therefore, at the highest, and taking your argument at its highest, this will, your challenge to section 7 and 10 has to be deferred to a point when we have ruled on the legality of the claim to a same-sex
Well,
marriage.
may I say why that might not be correct? Just give me a second. Well, your lordship will the first step have to see whether I am same-sex marriage recognized under SMA. That was my lord observing. That gives me access to marriage under a secular agnostic statute called SMA. It does not give me equality
also
with my...
Dr. Singhvi, you have to argue on a demurrer.
Yes.
You have to say that even assuming that you are not with me on the same-sex marriage issue, even then, my challenge to section 7 and 10 will survive. Can you say that?
No, but that I'm not arguing, Wallace. I'm arguing on the basis of both. I'm arguing cumulatively. I'm entitled to say...
But we would have heard you in your petition
No,
on
may I say-
section 7 and 10 if you were right in saying that even if you hold against me on the first point, my second point will survive.
May I put it like
Your
this?
second point is really dependent on the view which you
Wallace,
take on
I
the
bow
first
down.
point.
I bow down.
And therefore, at the highest, what we can do is this.
The two are inextricably intertwined.
At the highest, what we could do is this. Assuming, because we are now testing the hypothesis.
Yes.
Assuming that we give a declaration as that you want, that you are entitled to a right to marry under the Special Marriage Act, that there is a right to marry, so on and so forth. We can say that this particular issue will be dealt with separately in a petition which you will file or in the pending petitions where you may have intervened.
Petitions are there on this specifically. Mine, Mr. Rajaram Tanda's, others, or directly, already pending here. And they were mentioned, they were added
Because
to this.
notice applies to those who are entitled to marry undoubtedly, because that's why a heterosexual couple, there's a square challenge. But we can't hear your challenge unless we rule on your basic point.
Well, I leave it to your lordships with 2 points.
Singhvi, we might be putting the cart before the horse.
Well,
That sense of the.
May I just say this?
That's
I'll
why
leave it
we-
at that. Let me state my point and I'll leave it. My point is, number one, your lordships would decide certainly the declaratory part under SMA. Number two, my point is, when I bow down, my second point of notice and objection arises only if your lordship holds me eligible under SMA, no doubt. However, I say that if your lordship so holds in the first part, the other is inextricably intertwined. It follows, it's consequential. Without that, much of my right is hollow. And thirdly, Malas, the ultimate objection to this is what? I mean, we are in the Supreme Court. Your lordship will hear another combination. But the only objection is that he has not argued. Your lordship will give him a fixed time, half a day, and we'll finish it off tomorrow. Malas. I have already argued. We will take less than 50. At the end of the day, your lordship is rightly concerned about natural justice. And I'm not suggesting your lordship violates that, Malas. That's Malas, the only way to put it, Malas. Otherwise, I leave it to my lord, Malas. It's a very, I will show, Malas, at the end 10 minutes, why, Malas, assuming your lordships were to give me a declaration that I am a same-sex valid marriage under SMA, the vulnerability, the practical operation, the invitation to violence will make that right 50 to 70% illusory. That's the reason, Malas, your lordship completes the... Obviously, if your lordship doesn't hold with the first part, there's no point. Your lordship doesn't have to bother. What will, at the end of the day, what is the objection? He didn't get a chance to argue. According to our understanding, I was not here. My learned friend tell me, lordship said, we'll see later. The lordship did not exclude the point.
For a particular reason which will
Did not exclude the point. Therefore, Malas, I suggest, at least let me finish my argument on that, whatever little argument I have. Your lordship may, Malas, accommodate him in, it's a very short point. He can, Malas, show those sections that their lordship may have a little bit of spillover.
You respect, Dr. Singhvi. With due respect. Yes, sorry. Yes, please call.
Yes. Dr. Singhvi, see, what is being suggested to you is, let the bench rule on the principal aspect. Are you entitled to the declaration of a marriage or not? You are talking about the right post that being illusionary in some manner because of consequences which may flow. It's not that you are being shut out of that right to argue that.
I appreciate it.
The thing is that it is being felt that since it's an interlinked issue both for the same-sex marriage as well as a heterosexual marriage, it may be more appropriate to hear that out in a particular manner, looking to both sex of the people. I don't think that should trouble you so much.
I cannot say more than that. I will leave it at that.
There are only two things which can happen. One is you get a declaration. in which case you are heard on the second aspect. Second is you don't get a declaration, then really you can't argue that.
Well,
So it's cutting
I appreciate what my lord is saying. I bow down to it. I will not say more. I made my 3 points. Whether your lordship then still would want to hear it at a subsequent hearing, that's your lordship's prerogative. But I would still say the lordship will consider seriously my 3 submissions. That's why your lordship should hear it in this bench. But I don't want to. I want to move.
Now, on the main matter, you said you had 3 points, basically 3 heads.
Third was this, fellas. Third was this.
Right. What is
the first is, fellas, there are constitution compliant reading of the Special Marriage Act is within, don't give it down, is within the bounds of legitimate statutory interpretation. That's the first head. They are the heads, fellas. It is neither judicial surgery nor judicial legislation. There are 7, 8 major points under this. I will itemize them and go one by one under them. My second major head, Malas, is to Malas, assure your lordships and assuage all the needless apprehensions created, to show to your lordships, Malas, that the relief I seek, in one sentence, Malas, I am a valid, recognizable same-sex marriage under SMA. That's the proposition. I am, my second head of submission is that the relief I seek is workable. So the workability head. And neither requires this honorable court to create any new social institution. Many of these are phrases picked up from the respondents.
Social institution.
Nor to have a new definition of marriage. Nor to have a new definition of marriage. These are all again phrases by the respondents. Your lordship will be creating a new definition of marriage. Your lordship will be creating a new social institution. Nor, thirdly, nor entering into any thicket of personal law or other related laws. My third set of head, Josh will note it. Josh will decide whether to hear me now or later. Just note the head, brothers. I mean, this is the
sure.
That, brothers, the prayer for striking down the notice and objection regime of the SMA. The prayer for striking down the notice and objection regime of the SMA. You keep it here and there. Is an essential and indivisible component. Essential and indivisible component of my prayer for marriage equality. My whole case is about marriage equality. This is an essential and indivisible component of that prayer for marriage equality. Your lordships, without this third head, would have granted a recognition of same-sex marriage, but not equality. It would be a recognition of same-sex without equality. We are seeking two things. One is marriage equality. Your lordship would in some sense grant marriage, but not equality without this third. That's why it's important. And as my learned friend rightly says, without recognizing the extreme vulnerability of the class which faces this notice and objection regime, well, much of the relief might be made illusory. It's a very, very clear, strong, special vulnerability. I will stick to these three heads, Willis. I'll start with the first. Now, Willis, all these are points under the first. So, Lalit, just 2 sentences on what is the heart of my claim and prayer, and then we come to the first head straight away. Well, as I've said, we not only seek, or we do not merely seek, a declaration of the right to marry, which is one way of putting it. Of course, the solicitor opposes even that. One particular class of respondents said, yes, you may give that, but not go further. We do not seek, Bharat, merely a declaration of the right to marry, but a right to marry under the SMA by an interpretation of the SMA which would allow for solemnization and or registration of non-heterosexual marriages. That's the heart and the complete case. Therefore, Malaz, what we seek is a right to access on equal terms. We are seeking a right to access this social institution called marriage, and on equal terms. The irony is, my learned friends accept that it's a very sanctified social institution. People must have access, but they say not you and not on equal terms.
Through law.
So, Malaz, in a nutshell, this case is about interpretation to apply an existing law in a non-discriminatory fashion. There is no judicial legislation, no judicial surgery. Your lordships, Malaz, have done much, much, much more. interpretation of an existing law, no new lawmaking, but in a non-discriminatory fashion, which has two components. A, I should have a right to access on non-discriminatory terms. B, on equal terms. Now I come to my first head, straight away. First head. Melis, the heart of this matter is what? Your Lordship is well, I'll deal with this bogey of excessive reliance on the legislature. I'll be dealing with this constant argument. What is the Constitution? Just to digress for 30 seconds, the Constitution is supreme. Because your Lordships, fellows, interpret entrenched rights in a counter-majoritarian manner against the majorities. Every day, your Lordship, the whole Constitution about interpreting and applying entrenched rights against the majorities, against elected legislatures, against electoral majorities, which your Lordships from the framers' time thought could become tyrannical and dictatorial. Otherwise, there'd be no constitution. This constant hearkening that you are the judges, unelected judges who enforce entrenched constitutional rights against elected legislatures. Because our constitutional forefathers said that many rights were entrenching precisely because they have to be a counter-majoritarian against the elected legislature. What is so great about a legislature, Melis? Now, Melis, kindly go one by one, Melis. Therefore, Melis, consequently...
Except very small, very small detail,
yes.
That the legislature is the one which has created this SMA.
Yes.
If you rewind and there were no SMA,
yes,
where would that right flow?
Well, it's very simple. Let us be very candid, Melis. We cannot keep fictions anymore. The legislature made the Constitution, but it made the Constitution supreme and a special majority to amend it. In other countries, that is enough to say the Constitution is supreme, not the legislature, not the judiciary, not the executive. Here, your Lordship put a supra-added basic structure on it. And who says what is basic structure? Your Lordship say that.
All that is fine. We rewind to the position that existed before 1954.
Yes.
Where could an interfaith couple come and assert that right? That is where exactly you stand today.
Now, Melis, it's a very good, interesting year your Lordship is giving. I have in my written submission even put a photograph. That's a very interesting year my Lord Justice Bhatt is giving. Melis, Brown versus Board happened around that time. There were people who wrote that these are the documents of the framers of the 14th Amendment who said you can never have equal but segregated. The original intent was against. They said we will now interpret it in accordance with evolving times. And the photo I put in my submissions, Melis, is an iconic photograph of 1960 with 4 white marshals escorting a black guard. Purely counter-majoritarian. The 14th Amendment, Travaux Preparatoires, suggested that the original intent was not to allow this desegregation. And the judgment records it. It's a judgment not in the compilations. And a 9-0 judgment in 54, Justice Bhatt, at that time, we are now, what, 75 years down the line. Because it is, evolving. I have got 2 other interesting examples when I do some research for this case. I'm digressing, but a very interesting example. You should be shocked to know. There were laws passed by legislatures of USA, the country which is the most advanced country in the world. One law said that male people below an IQ of X must be sterilized.
Eugenics.
Because you should not have a society of idiots. I'm being blunt, but that's virtually what judgment says. That judgment was upheld. I'm sorry, no, the law was upheld. Holmes. Second example is very, very interesting and very relevant for today. Well, the biggest change from my time when I joined the profession is, among other things, that from being a refuge of last resort, law is an option of first choice. You would you'd fail 5 exams and then come to law. Now, it's an option of first choice. Secondly, people with no background in law are coming to law. With no correction, fathers, grandfathers are coming to law. Third greatest advance is women. The number of women, when some of us started our profession and now, is radically different. Whereas the second law passed in USA was women should be barred from joining the legal profession because of the roughness of the profession. Women are not suited. Also upheld.
We were the first to do away with that.
I beg what?
We were the first to do away with
That is much more advanced. Now, Maharaj, these are, therefore, this whole concept, original intent, legislature, it is unelected judges who are the masters of interpretation of the Supreme Court, of the Constitution. The whole idea is to entrust that power to a class of people who are not buffeted by the majoritarian trends or the majoritarian ethos of a time, which can at times be tyrannical and dictatorial. Well, part 3 is nothing but a counter-majoritarian part 3. What is part 3, Manas? It's an entrenchment against the majority. Articles 25, 26, 27, 29, 30, nothing but counter-majoritarian, Manas. So it's no point repeating. Yes, if your lordship finds that the Ghedan, which is completely test, I am asking 10 units ahead of Ghedan, then it might be judicial legislature should not do it. But don't not do it because the legislature may do it. That's not a valid reason. If your lordships find that your lordship has to do much more than even Ghedan allows, then your lordships may not do it. If your lordship finds that this is not a correct thing to do, your lordship may not do it. But please don't be swayed by this constant majoritarian argument. Elected legislature, unelected judges, majorities. But the whole advance of law is replete with examples to the contrary. There will be no advance in the law, and we are now talking of Brown versus Board of 1954-55.
But now you just said that if you feel that it's not a correct thing to do, then don't do it. Or in other words, if you feel that it is a correct thing to do it, then by all means do it.
No,
problem is that
even there within limits.
The problem is that the court decide these issues of correctness or otherwise when they are essentially issues of legislative policy and in the legislative.
Your lordship knows it better than us. Your lordship has done much more in the course of interpretation.
Does the judge decide that this is correct and therefore we will do it? Yeah. Or is this something which properly called is for the legislature to decide as to whether it is correct?
I would even go so far as to say that there is a value judgment involved in all these cases. Was Navtej not a value judgment, Manas? Why is Navtej not a value judgment, Manas?
No,
Navtej was, the court was within its constitutional bounds.
Because there was a challenge to validity of
challenge.
Is it a challenge, Manas, by reading down that Article 14 and 15 excludes me on ascriptive characteristics? That's the one sentence summary of this case. Your lordship is preventing discrimination which is practiced by the application of discrimination against me on ascriptive characteristics. Directly 14,
therefore, let's understand your submission.
Yes.
Your argument is that any notion of marriage as a social institution which excludes same-sex couples would be violative of constitutional precept. All right?
In particular, 14, 15, etc.
That's right.
In particular.
Their argument is that marriage is conventionally understood.
Correct.
Is a heterosexual union between man and woman.
Correct.
You are saying now, in order to make it constitutionally compliant, read that social institution as also comprehending within its fold
lordship, please,
the union between a same-sex couple.
Because, no, not only that, one sentence more.
That's very different from what we did in Navtej.
No, I'm saying, on one ground. One of the grounds of an ascriptive characteristic, one of the grounds
started the debate by saying that the Special Marriage Act provisions are void. You have not. You have said that it is raised in
if I can
manner.
kindly,
if you read it literally, it leads to this.
Kindly see what my Lord has formulated.
Thereafter, you brought in all this.
Kindly just see what let me answer. Give me a minute. It's very important. Kindly see what my Lord has just formulated. Therefore, I could enter the gate with a voidness challenge on SMA.
Yes, you could.
Yes, fellas. Can I not ask for lesser? Your Lordship,
That's
read
not
down.
the point.
Your Lordship.
Question of lesser.
Fellas, kindly.
Question is, you should be able to say this is a wrong classification. I'm taking it head on, strike it down.
No, with respect. The striking down would be on the same articles.
See, this is a very artful way of putting it, if I may say so. This is very artful. You are not taking it head on. You are saying that there is a classification which is illegitimate.
Yes.
But you are not willing to take it that far because you have no locus.
Can I just
You have no locus.
I don't, with great respect, no locus may not be right.
You are establishing, wanting to establish a right by by opposing a negative, that this is void.
So let me meet both those points. It's a very important part of the debate. Number one, I am entitled to challenge it on the ground of discrimination and an arbitrary exclusion, but the consequence, my lord is saying, must be strike down. Malice, if your lordship, within the bounds of judicial review, if, forget this case, are able to read down something, does your lordship not 100 times uphold the act by reading down? Forget this case, Malice, what your lordship do? Is the technique wrong?
The technique is not proposition one, if I may say so, is the classification there is valid. Now you want to push it forward and say it is a valid classification, but
no, I'm not saying it's valid classification. I'm not saying valid classification. I'm
then
sorry.
in that case, heterosexual classification is not valid according to you.
No, your classification which is invalid becomes valid by your lordship's reading spouse, person, everywhere. It can become valid, but the lordship does it in every law.
But Dr. Singhvi, there was no argument of it being ever invalid. The argument was we need the same benefits as are flowing to those who are in a
Otherwise,
marriage.
otherwise it would be bad. Otherwise, the law would be bad.
But you never laid a challenge to the very statute.
No, Malice, I'm saying I am entitled not to raise.
As we understand.
No, Malice, I'm asking, forget this case for a minute. As a proposition of law, my lords should not think that there is any sleight of hand. Just for a minute, forget this case. As a proposition of law, am I entitled to come to your lordship's court and say, A, I have direct locus. I'm directly agreed because I'm that class which is excluded. So there's no question of lack of locus. I am that class excluded. Second question, I am the class excluded because the exclusion occurs on ascriptive characteristic of gender or sex or identity. Third, if your lordships finds that there is an exclusion, then while normally the law would be struck down, I am giving you clear, simplest, minimalist answers as to why a reading of person and same sex or spouse will validate the law. I don't want to change any other part of the law.
Dr. Singhvi,
why am I compelled, to challenge its validity?
Even if you were to challenge the constitutional validity of the Special Marriage Act, even if you were to challenge the constitutional validity of the Special Marriage Act, that would be postulated on the hypothesis that any statutory recognition of marriage as being confined to a heterosexual man and woman is unconstitutional. In other words, what you would then seek is an expansion by the court of the very notion of marriage so as to include a class of relationships other than a heterosexual relationship.
Absolutely.
Right?
Absolutely.
That exactly is the problem, because then what happens is that the court, in the course of reading down, which you are then suggesting that it should be done, would be reading down the statute in a manner which would expand the dimension of the social institution, which is what you seek.
No, call it reading up. I have no problem with that semantics. Call it reading up.
Reading up
reading up
down?
is
What you are then going to say is that, look, the Special Marriage Act has taken account of marriage being a notion involving a man and a woman.
Yes.
This is unconstitutional.
Yes.
In other words, actually, if you stretch it further, that any notion of marriage itself being a union between a heterosexual man and a woman is itself unconstitutional.
Now, can I just answer that?
Now, can we go down that far and say that, look, the very social institution of marriage, as including a relationship only between a man and woman, is unconstitutional? Even you won't take it that far.
No, Malas, we are saying in the event that you're...
As a social custom.
No, Malas, we are saying that...
It's amenable to Article 13.
Malas, I'm sorry.
You haven't also taken it that far and you won't take it that far.
We are saying...
So what is your next line of argument that by recognizing marriage only in terms of a relationship between a man and woman, the legislature has infringed 14 or 20?
All that we are saying is that if you continue to read SMA to exclude same-sex couples, then the SMA as a legal proposition is unconstitutional under 14, 19, 15 and 21. Just allow me, I've heard it also loud and clear. First point, marriage as a legal institution needs my access on equal terms as heterosexual couples. My stoppage of access and also not on equal terms is my violation of 14 and 15. It doesn't stop here. Your Lordship, next question is, everything different is not unconstitutional. Let us see what is the difference based on. That's question number 2 in an Article 14 analysis. My answer to question number 2 would be that this differentiation, which leads to the exclusion of same-sex couples, is based solely on ascriptive characteristics. Solely. Question number 3. If it is so, then normally its exclusion must be struck down. Kindly bear with me, I'm answering question. The exclusion must be struck down. Now that may lead to situations of inclusion.
So this part we've understood your submission. What's the next?
But that analysis doesn't stop at 3. So first is there a differentiation, exclusion? If there is there a valid basis for it? These 2 I've made. Third still remains. Overall, is it something which your Lordship should not do after the first 2? Reading up or reading down. Because of a original intent prohibition. Answer clearly has to be no. Your Lordship have never followed original intent in that sense in this country. Fourth.
Dr. Singhvi, during the hearing on behalf of the petitioners, I think we had trodden all this ground and even moved on. And if I recollect rightly, you said that you would not urge any interpretation which does violence to the other provisions of the statute.
That's the workability.
That's where you ended it and the others took over. So now please focus on what is your core argument.
Workability part I'm just coming, Malus. That's the workability part. I will be showing your Lordships chapter and verse, the workability, because that is told to your Lordships. Today, Malus, I'm only on this, on the first part, a mere declaration of marriage or a declaration of a valid recognized marriage under SMA. That's the debate in the first head. I've not come to the second head yet, Malus. In the first head, it is our case that your Lordships must recognize same-sex marriage on these legal basis under the SMA. And for that, your Lordship has ultimately in the 4th test or the 3rd test only to see that does an original intent bind you? There is no such doctrine in India. Is there overall a policy of the law? The language is, it is permissible for a court to depart from the specific intent of the legislators as long as the proposed interpretation is consistent with the underlying thrust of the statute and within the institutional competence of the judiciary. If your Lordship is violating this test, by all means, I'm out of the first test. Well, this is a quote from Ghaidan I've just read, just part. Well, Ghaidan was much misrepresented, factually different, contextually different. I started when if your Lordship recalls my arguments, of course it is. I cited it for the interpretive doctrine of judges not being bound by sterile doctrines of the original intent or the specific intention of the legislators. That is the only reason I've cited.
We don't need to go to Ghaidan. We have our own homegrown Ratan Arya
and your Lordship have in fact travelled much more. That was an English case without the constitutional dynamics of this country. So, Malas, your Lordship's reading up and reading down in a much bigger way is commonplace. Your Lordships, Malas, in particular, apropos what my Lord just has said in S.G. Chaudhary, which is, Malas, in footnote 1 and one more judgment, Lakshmi video. They're all in my original compilation. Your Lordship knows S.J. Chaudhary is in my compilation, volume 2, at page 7094, and Lakshmi video is in my compilation 4, volume 2, at page 4510, held this simple proposition, which is sufficient. Application of a statute ought not to be forever circumscribed by the range of concrete circumstances that its framers intended it to apply to. This is your Lordship, 60s doctrine. Ghedan was one, I've given you Lordship enough in Indian law before that. Therefore, I submit.
There's an old one on 14. I think it's Jialal. Jialal is, I think, the one where those living on the other side of the Yamuna were not allowed to hold an arms license. And that rule was, created during the aftermath of the mutiny. I think it's 61 or 62.
Oh, yes.
So the court said that, what is this classification? See, that which was valid, because the insurgents were holding arms, they were concentrating in Meerut and that side.
Correct.
So they wanted to stop that.
So that was a contextual thing of that time.
Correct. So then,
that's right. Then, I go on this to say that your Lordship will then juxtapose it with the agnostic thrust of the SMA. Why was the SMA created? Today, after 70 years of the Republic, 75 years, we have a recognition that the numbers of same-sex or queer people is very large. They were always there, but they were not understood and recognized as a community, that they existed. There was fear on both sides, both on the heterosexual side and on the homosexual side. There was inhibition. Today, what is this case about, that your Lordship provided a secular agnostic platform for heterosexuals. Forget, this category. SMA's entire birth from two things, the long title and the SOR. I'm not showing it again, Lordship. And the text, especially 4, section 4. The whole purpose. Therefore, if the SMA was designed to facilitate marriages, actually, SMA was in that sense, not as much, I would say, but a very significant advance. Not so much as recognizing same-sex today, but a very significant advance because it was also dealing with marriages outside the pale of social acceptability. Social acceptability is the heart of SMA. Your Lordship wanted to create a platform for social acceptability, which is not there for heterosexual couples.
Now, just a little look at the clock, Dr. Singhvi. We don't want to keep it parted beyond the vacation.
No, tomorrow a little bit. I will not.
We have about 50 minutes. We'll rise at about 4:15. So between all of you, please ration the time now.
No, tomorrow, give me some time. Your Lordship, we do one thing. Rise at 4 o'clock. Give me about half an hour, 45 minutes. Tomorrow we'll finish this side.
Then I won't.
Workability. This is a matter of last rejoinder is the last stage. We want that time.
Singhvi, tomorrow is a clouded morning. We have a
reference.
Then we have 2 Constitution bench judgments which we are pronouncing tomorrow. Plus, today we had only 240 mentionings in the morning.
Your Lordship may slash
276, sorry, 270.
Your Lordship may shift the mentionings to next week, in a lighter vein, because this can finish too.
And then we have All India.
This is our last slot, in a rejoinder.
You can just
it's the last slot.
One after another. Tell us, because we have heard it for such a long time.
No,
this will be faster to grasp it. You just formulate it and then tell.
No, I'm formulating as I go along. I'm giving your Lordship every discrete point. I'm not repeating a point. But this is a matter of some moment. Your Lordship will give me some time tomorrow. I'll be very pointed. And your Lordship has time from 12 o'clock for this matter, or from whenever your Lordship finishes the other thing.
Only 10 minutes to give a suggestion.
I'll tell you what the practicality is.
Yes.
The reference will go on for about.
This is
What we could do is this, because tomorrow's schedule really, I mean, I must share it with you. We have the reference which we anticipate would be 10:30 to 11. Maybe perhaps a little longer.
Mentioning half an hour.
Then we have two constitution benches, give 20 minutes for that. Mentioning half an hour. So we would be able to assemble at about 12 o'clock. 12 o'clock. So 12 to 1, then everybody will have to wrap up between 12 and 1.
We'll finish it by 1 hour.
But Milord, I just want 5 minutes now, Milord. I have difficulty to-
Another 5 minutes after Mr. Rodgi.
Only,
Two of us will
I
finish.
want to give a suggestion.
We'll finish.
I want to give a suggestion. Milord, Milord,
If you could please do this, if you could wrap up by say about 3:50, then we can give 5 minutes each to Mr. Rodgi and Mr. Ramchandran, and then see who else remains there.
Let me
1 hour.
In 1 hour.
It's 3:30. Well, let me proceed as fast as I can. If I need 5-10 minutes.
Your Lordship may give me 20 minutes because.
Please keep going. Please. You are my friend. Take time tomorrow. Give me and Ramchandran 5, 10 minutes now, and he can continue tomorrow.
Anyway,
we will not just give.
Now we're in the thick and the flow of Mr. Dr.
Now, so let me utilize this time at least. I mean, let me just go.
All right, Dr. Singh.
Now, I'll go back. So, now, therefore, your lordships provided a platform of beyond social acceptability for heterosexual couples. All that your lordship has to see whether reading in or reading up within that social acceptability platform is beyond the pale of judicial review. That's the only test.
That's the point.
I'm not asking your lordships. I heavily disagree about judicial surgery.
What you're saying is Gaidan methodology and
not Gaidan, but principle.
Okay, whatever it may be, is equally permissible under the constitution.
Now, let's kindly turn to para 9 of my note, my written submission. I made a self-contained rejoinder submission.
Right? In rejoinder.
Yes, what is it called?
N.
It's got my name on the top of the rejoinder submissions by so-and-so.
अभी आया है दोपहर को.
From right now.
Where is that?
Yeah.
The mail is it?
सुनो अब तो इसमें आपने
we have got hard copy.
किया है. Rejoinder. There's a mail, is it? Mail में
volume up to volume 18, huh?
चेतन पेन ड्राइव में कहाँ पर है?
Up to volume 18.
Now, have you got page 9 at page?
Give us a moment, Dr. Singh. We're still looking.
Para 9 at page 5.
Joinder is a whole new world now.
Karunanand has given two.
Is it by way of the conclusion on this point, Dr. Singhvi? Does it begin like that?
Yes, correct. Justice Paul has got it. Para 9. That's correct. Justice Paul has got it.
हाँ किसमें डाला है?
Para 9 is well as at page 5.
Rejoinder folder अलग नहीं है मेरे पास.
It's a 37-page document.
There's annexures. There's actually 15 pages. It's only 15 pages. Or
yes, you're right.
15. How many pages? 19 pages. I'm sorry. 19. Rest is well as appendix.
You're right.
Now let's just come to 9.
Is the rejoinder folder as part of written submission?
Still looking.
Chetan?
Oh,
I came at lunch, therefore there was a problem.
Let it be located first.
It's sending it to you.
Justice Kaur and Justice Bhatt have got it.
No, we have it.
Justice Narasimha also has it.
No, he's getting 8 drops.
People also.
You drop it to me?
Dropping is, your thing is not on.
Mine?
No, this CJS.
It's on, yes.
Got it?
Somebody can just go that side and find it.
Because they took my pen drive to load it in the afternoon.
Can you hold it down there? They don't switch on.
Okay.
These written submissions in rejoinder.
Yes, just police computer.
Yes.
Just to
Yeah, sure. Just one second.
give us a moment.
It's a 20-page document. Yeah. It's 37 pages, huh, by the way.
37.
After 20 pages
20
is
is
the
submissions.
Yes, to argue and rejoinder. That's
Yeah,
it.
that's right. Para 9 at page 5, internal page 5. In the middle. Sorry. It was never in dispute that when the 14th Amendment was enacted in 1868, its framers did not intend it to apply to desegregation. Indeed, it is popularly recounted that many legislators who supported the amendment supported segregation and the separate but equal doctrine. In Brown, however, the US Supreme Court discounted the specific application intent of the framers and asked itself instead what the principle of equality required of it by way of constitutional interpretation. Similarly, petitioner's interpretation of the SMA focuses upon the underlying thrust and the principle of recognizing and legitimizing marriages unsupported in social conventions, upon which the SMA is founded, rather than asking how the framers intended to decide. That question is wrong, I say with respect. Now I'm putting that photograph, I've said anti-majoritarian impulses. Unpopular, I'll skip para 9A, but that's an iconic photograph of the 1960s. Come to para 10. Petitioners respectfully submit that the remedy does not involve any judicial surgery, nor the creation of a social new institution, nor a claim for legislation. These are words used by the respondents. Now kindly see what it involves. Rather, the issue before this court is one of discrimination of non-heterosexual persons from an already legally defined institution on the basis of the prohibited markers under Article 15. Malas, one thing more, Malas. Your Lordship is told social institution. Today it's more a legal institution because your Lordship under the SMA is excluding personal laws. It's a misnomer to again and again bring this scarecrow argument of personal laws. It's a legal institution under SMA, not a social institution. I'm not saying marriage is not a social institution.
It's not as it is
not.
It is
It
is enabling the marriage, but it is also assimilating.
I bow down. I don't want to use the word absolute. My lord is absolutely right. That I'm not going that far. I'm just saying, a large amount of that social institution part has been circumscribed by a legal construct, which is what SMA is. Prior to that, your lordships could not venture there without personal laws. That's the point I'm making. Now, just see the middle of para 10 is very important. I've taken the liberty of highlighting it. A right to marry, along with a scheme for its implementation, already exists. Petitioners are only asking for a non-discriminatory access to their existing right and institution. Indeed, petitioner's request is modest. It is to interpret certain provision of SMA in a manner that is both constitution compliant and consistent with the SMA's own underlying thrust. Contrary to the respondent's submission, this does not involve the court in altering the meaning of words or the meaning of marriage. It only brings into the ambit of the SMA a class that was unconstitutionally hitherto excluded. Well, your lordship is just pause here. I'm not on the notice and objection. Your lordship is now being told an equation between right to marry, a declaration to marry, versus a declaration to marry under SMA. Well, Cicero's words are important. Well, Cicero said that a room without books is like a body without a soul. Whereas your lordship is being asked by the other side that you recognize an abstract right to marriage without anything under the SMA is really being asking for a body without a soul. That's my submission. That I've said in para 10 capital A. And we have a quote in the top of my submission, which I need not. Mary Robinson, President, Ireland, and also the promises of human rights are like empty shells if they are not backed by concrete actions and meaningful change. May I say, your lordships is, what is your lordship being asked? Give a declaration of marriage, but nothing to do with the SMA. These two words, empty shells, apply, body without a soul, apply clearly. Now, 10B, I've said legislative majorities did not decriminalize. Forget 10C, come to 10D. 10D for a minute, It is respectfully submitted that legislative will is not necessarily a neutral, objective, or meritorious manifestation of desired constitutional objectives and constitutional morality. The Constitution is supreme precisely because in many areas it digresses from the wishes of mere electoral majorities. The zealous guarding and upholding of several minority rights, including its many nuances, is crucial precisely because electoral majorities are presumed to be wrong, tyrannical, or oppressive at certain times. So, this is an excessive misplaced reliance on elected majorities and unelected judges on the other side of the equation. Now, let's go to workability, which is the heart of the matter, because I must assuage all these huge apprehensions, which I'm going to show are largely red herrings, created to create some kind of a fear issue that, oh, what is the lordship being asked to do? How far a lordship will go? Now, let's please see. The main part of this workability or lack of workability is personal laws. That your lordship is being dragged into personal laws. Just bear with me, this is a little important and I'll go a little slow. Just come to the third line of 11. In particular, section 19 of the SMA severs ties of persons of Hindu, Buddhist, Sikh or Jain religions married under SMA from their undivided family. At the same time, 21 provides that succession to the property of any person married under SMA is under ISA. Now, the main argument on which, on the very tenuous, thin argument it is argued by respondents is the last 5 lines. Respondents argue that 21A of the SMA carves out an exception for marriages among persons of these 4 faiths, stating that they remain members of their undivided families, last 4 words, thus linking them back to religious and personal laws. Now I'm trying to answer this first point. Well, I've given 2 important tables in para 12. Just see the first table. Prior to 20, because the entire argument is 21A brings back a very minimalist, but a small amount of personal law. Now, prior to 21A is my first table. Everything is ISA. Let's kindly go a little slower. It's very important to remove these apprehensions. Everything in my first part of the table is ISA. ISA is supposed to be an agnostic, civic, secular law, which goes in tandem with this equally agnostic, civic, secular law like SMA. There is no Hindu, Muslim personal law involved. And the first part, even for Hindus, is a severance from the HUF. All the columns are ISA, 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 Muslim, Christian, everything. Now, after 21A, it remains the same, except for a Hindu couple. Well, I hope I'm clear on this. Except for a Hindu couple, the second part of my table is identical to the first part.
What you're saying.
Now, let's kindly go. Yes, therefore take it slowly. I'm dealing with that. Petitioners submit that 21A does not create a barrier to a constitution-compliant reading. 21A only applies for marriages of two Hindus. Further, even when two Hindus marry under SMA, 21A links the SMA regime to personal law for only two narrow aspects. The whole case should go out of SMA because of this argument, according to respondents. Succession and membership of HUF. Succession and HUF, that's all. So 21A is A, limited to succession and HUF, second limited to two Hindus. Now, let us kindly come to my answers. I am respectfully submitting three possible interpretive answers. And your lordship, I am neutral to all. I have a personal choice. It doesn't matter. There are people here, other people. All three, according to me, it's a scare argument to say that so much big is happening, whereas these three, any one of them, of lordship's choice, answers it. Firstly, theoretically, this honorable court may elect not to pronounce on the applicability of 21A to non-heterosexual Hindu couples in the present litigation and leave questions of succession open for future litigation expressly. That's only option one. See option two. Secondly, in the alternative, the honorable court may hold that the SMA will apply to non-heterosexual couples exactly as applies to heterosexual couples. Today, our lordship has it applying to heterosexual couples. By virtue of the introduction of 21A, specifically, Hindu non-heterosexual couples will be governed by the HSA, just like Hindu heterosexual couples. But all non-Hindu, Christian, Muslim, will be governed by ISA. This is number two.
But to achieve this reading, now read what follows.
Yes, yes.
What do we have?
Well, I have to. Is your lordship's shy of doing this minimalist interpretation? Will be the question. That's a valid judgment of your lordships. If I'm asking for something which your lordship has never done before or is unknown to your lordship, is right. I submit this is a minimalist. See the next. Yes, next para. Next para. This is minimalist, is my submission. To achieve this reading, the Honorable Court may extend its gender-neutral reading of the SMA to the HSA and the ISA. That's all the lordships do. Whatever it has to hold: one, widow and widower in the ISA, and male Hindu and female Hindu and widow and widower in the HSA shall be interpreted in a manner that is agnostic of gender and sexual orientation. That too, Malas, there are two options. By specifically saying personal law is out.
Really have to then recast or redraft the provisions of the Hindu Succession Act also.
No, Malas, your lordship, it doesn't have to recast it. Your lordship has to say, no, my lord is only in SMA. My lord is not going to HSA. My lord is saying either of two things.
Saying that to achieve this reading,
yes,
this honorable court may extend its gender-neutral reading of the SMA to the HSA and ISA. It may hold that the words widow, widower in the Indian Succession Act, limited to issues of marriage, and male Hindu, female Hindu, widow and widower in the Hindu Succession Act, again limited to issues of marriage, shall be interpreted in a manner that is agnostic of gender and
Correct. Now, what does it mean? Give me a minute. It's very important. Give me a minute. It means that your lordships will first put a caveat in the beginning: we are not getting into personal laws. Second, cumulatively, your lordship would say that today all heterosexual couples are governed with 21A in only ISA, except for Hindu couples. So the large majority of non-Hindu couples are covered by ISA. Third.
The largest number of people.
No, that's the third. So I'm not avoiding it. I'm not avoiding it. I understand. My lord is right. Third, for the Hindu couples, the agnostic reading will be to words like male, female, widow, widower.
In other words, we are creating a new regime, essentially. There.
That may not be a new regime. That is even.
No, it's not. If you go down, drill down a little bit, the complication.
Yes.
Now, two spouses of the same sex.
Yes.
One dies. Now, who will that be? What is the kind of estate that she?
If your lordship adopts, if your may I read?
Well, then you see, when it comes to a male, of course it will be a son. He will be treated as a son. When it is a female, she will be treated as a daughter. Question is, what is that spouse? Will he be treated? Will that spouse be treated as husband?
When a male Hindu dies interstate, but the first priority is to the widow.
Yeah.
If it's a same-sex male couple and the male has died interstate, there'd be no widow.
No, but there will be.
So what you are now therefore saying is that read widow.
Reading that to be a compliant. It's the widow.
Another word widow.
Willy-nilly, we do enter into personal law.
Or,
See, this formulation has one.
surviving spouse.
No,
That's true.
See,
That's true.
it's a bit oversimplistic. Hindus, you say only Hindus. No problem. But at the same time, there is no problem when it comes to Indian Succession Act, where the Christians, it anyway applies to them.
No, I have no problem with
Then
ISA.
we come to the Muslims.
21 is creating a problem.
Muslims are the one who are now bound by the ISA.
Yes. No, may I just.
Others.
No, may I just say, there's a third option I've given. The problem is arising because of 21A, which takes you back. It is not arising for any other category. So Muslims and Christians who go under heterosexual couples under SMA go under ISA.
But Dr.
Now, the third one is.
Look at how that third, you are yourself struggling at an intellectual level. You say it is submitted that there is a third option.
Yes.
That this honorable court may hold that since religious and personal law related issues by agreement of parties are beyond the scope of
That's what I started the matter with, Balas. We are saying outside.
We can't rule on.
No, but we started the matter
by
by
saying
saying.
that look, by agreement of parties, this
No,
has been
forget agreement,
create a minefield for a future bench.
Malas, forget the agreement. Your lordships is saying that from the inception, the petitioners. Malas, the petitioner. Kindly read the whole.
You have to then decide it.
No, Malas, kindly allow me. No. Well, kindly read the whole para. This matter started by the petitioners who invoked your lordship's court to say we don't want to get into personal laws. Your lordship can certainly rely on that petition. But now read the whole para. Just allow me. Third para. It is submitted the third option. This honorable court may hold that since religious and personal law related issues, forget agreement of parties, kindly delete that word. I mean, I don't want to, not necessarily, are beyond the scope of this litigation, which your lordship declared at the beginning when the matter started. It follows that personal law statutes as well as provisions of secular laws that relate back to personal laws, that is only 21A, are excluded from consideration. Since 21A itself was introduced as an exception to the regime under 19 to 21, non-consideration of the issue would simply mean a reversion to the default regime of ISA.
So are we reading up or are we reading down by doing that?
Well,
Which of the two would it fall under?
Well, I am saying there are two options. Either it will all fall under ISA or your lordship may apply the spouse and person interpretation for HSA Hindus.
Then we come back to the old position that when it comes to same-sex couples, we will interpret it in a particular manner. When it comes to heterosexual couples, we will read all those laws in a different manner. Well, we will have to have those two different interpretive tools.
Well, so can I just summarize? After a preliminary statement that when the matter started, your lordship had made it clear and the petitioners have also said that there is no going into personal law, your lordship may adopt either of two. Allow me to summarize. One, that everybody is under ISA and 21A will not apply to the same sex. Alternatively, that everyone is under ISA because ISA is not posing a problem. But for same-sex Hindu couples, your lordship reads the word spouse or a word person. That's the summary of the whole thing. That much your lordship will have to do. If it is beyond the bounds of judicial writing, it is beyond the bounds.
Should we include Hindu?
Please see the logic in my para 15. But I am saying this cannot be the complete exclusion which the respondents
Then there is a classification amongst the same-sex couples. You are saying that those who fall in 21A, you treat them differently, leave it at that. For the others, you have ISA.
No,
you are actually subclassifying now.
No, not in the second option, in the third option, yes. In the second option, the better option is whether your lordship interprets it to mean spouse or person. Then there is no such
Hindu non-heterosexual couples would be governed exclusively by the ISA, according to you.
How is that possible?
On option 3, not on option 2. This is important. Let us forget option 3.
Then neither are we reading down, nor are we reading up, nor are we striking down 21A.
No, so let me leave aside option 3. Let us say that your lordship keeps 21A.
Dr. Singhvi, we are not writing a blog, we are writing a judgment for society.
Your lordship is keeping 21A. Let me tell your lordship how I would respectfully submit a judgment can be written with 21A existing. It will certainly not be a blog.
You may have that legislator's pen elsewhere. But you can't persuade us to use this here.
I can only make a submission. Well, it's how, let us just for a minute focus on 21A.
Yes.
Your lordships may adopt the second option. 21A is given full force if your lordship reads the word spouse and person. That's one sentence answer. Forget the third option. 21A is excluded, as my Lord Justice Bhatt said, only in the third option. In second option, since 21A is there, your lordship applies it, but your lordship would have to do person or spouse that much of reading. That's the long and short of it, Malas. Now, is it such an insuperable thing that the whole case, Malas, should be a mere declaration of marriage? Then, Malas, there is virtually an empty shell. Malas, I would say it is only, Malas, a cardiac checkup.
Or is it a transplant?
Malas, that too, a cardiac checkup, Malas, that too by a physician, not a surgeon.
Ultimately, we are
Physician.
Court, please have heart. That's what it is saying.
That's neatly put.
Well, let's just see the conclusion at para 15.
Yes.
Just see the conclusion at para 15. Because then I have these special categories coming after that. It would not follow from this approach. Now, I am giving the answer to a possible objection to my approach. It would not follow from this approach that non-heterosexual Hindu couples who marry under SMA would be excluded from legal succession regimes altogether. Today,
We'll resume tomorrow. I think it should be around
12-ish.
12-ish. But we'll resume the moment we are ready.
Yes, I'll take very little time.
And now for all of you on this side, 1 hour flat. So please in the evening, take out time.
Suggestion, but I only want to make a suggestion.
Yes.
I don't want to argue, Milord.
Yes, Mr. Rodgi.
Milord, my suggestion is this. If you agree, Milord, to some part of SMA, then, Milord, it is there.
Then, sorry.
If you don't agree to SMA, I am making that suggestion as an alternative. Suggestion is this. That, Milord, your Lordship grant us a declaration that we have a right to marry. Now, Milord, we require in reality some state recognition, a document that yes, you have got married. I go to a bank, I go to an insurance company, I want an insurance for a family. I need to have a document. I can't go with the judgment of the Supreme Court and say I have a right to marry and I am married. The bank manager of the insurance will say, show us some proof. Therefore, I am submitting that, Milord, a document of marriage by way of an affidavit between two parties that I take you as a spouse in marriage can be, Milord, a via media for registration under Section 18 of the Registration Act, which is registration of an optional document. So not SMA. So I steer clear of SMA. I have, Milord, two affidavits. I take you as my spouse. You take me as my spouse. That affidavit, Milord, form I have taken from the Act. With that affidavit, I can go and have a registration. So if I go to a bank, I can show, Milord, I have some registration. How else will it happen? Milord, Section 8. I need some document.
We'll come back.
So just keep, Milord, Section 18 in view. 18F is an optional document.
This is obviously wholly without prejudice.
Yes,
we are asking something totally.
I'm saying steering clear of.
Wholly without prejudice.
I am saying so. I am at the last, I'm the bottom rung.
After he says. We can't get everything, we have to take what we get.
Yes.
Lord, may I just take two?
Tomorrow.
Your Lordship, Lord, can I just take two?
Tomorrow, Mr.
Lord, can I
It's already 4.
Tired souls are not receptive souls.
And the heart would still be in the right place.
From
Online you want? Sure, certainly, no difficulty about it. Yes, come online, no difficulty. Then inform you online.